Hi there, this is NDTV Profit and you're watching The Fine Print. Amazon, Google, Flipkart, Apple, Uber, Ola, Zomato, Swiggy and the likes. Digital giants of e-marketplaces, food aggregators, cab aggregators, search engines will soon have to deal with the new law in India, and that's the Digital Competition Law, proposed to check abuse in the digital world. The committee submitted its report last week saying we need a predetermined framework to check anti-competitive conduct. So, will this proposed law make digital world fairer? To answer that, I have with me Avaantika Kakkar, partner at Cyril, Amarchand, Mangaldas, and Nisha Uberoi from Trilegal. Nisha, Avaantika, welcome to The Fine Print. Nisha, I'll start with you. In your opinion, we don't need this new law. Why is that?
Thanks, Payaswini. The reason that we don't need this new law is because the Competition Act is already sufficient to regulate digital competition players, as is evident. The CCI has had over 25 ongoing investigations, whether it's food delivery platforms, whether it's cab aggregators, whether it's search engines. The CCI has been able to effectively investigate these players despite them being digital players, and has in certain instances imposed penalties and directions on behavior. So it's not that the regulator cannot regulate them. The reason why they're looking at this particular proposed digital competition bill at the moment is because, just like Europe, they want an ex-ante framework on the basis of the fact that investigations and appeal processes are time-consuming, digital markets are dynamic, and tip quickly in favor of a winner-takes-it-all approach. Unfortunately, at the stage where India is at today on its economic development, priorities should be growth, innovation, and investment, and a level playing field which allows players to grow, not curtail their growth upfront by virtue of precautionary antitrust economics, which is what an ex-ante law is, and therefore this is not the right time to introduce this proposed digital competition bill. Europe might be #1 in terms of regulation, but India is very much #1 in terms of innovation, and therefore we should not blindly copy what's happening in Europe here in our economy at this stage.
Sure, Nisha, Avaantika, and before I should have done in the introductions, you guys represent some of the largest players who are probably meant to be covered under this proposed law. But I'd request you to not sort of probably speak on behalf of your clients today, but as sort of practitioners of the law, to try and understand, the need of this new law and how will it be implemented. Nisha, I take your point that, we are probably not at the stage where a developed jurisdiction like Europe is. But under the current Competition Act, the CCI has to look at whether the entity is dominant or not. You have to delineate relevant market, and expert councils like yourself and Avaantika, who I'll just get to in a minute, will move heaven and earth to make relevant markets as broad as possible so that your clients don't end up being called dominant, and then the abuse then sort of quickly fizzles as well. So help me understand that, we've seen, like you said, you need to give a level playing field, but it is not a level playing field, right? There are, in most sort of sectors, or rather spaces that I called out, we have clear sort of market leaders, right? And for the smaller guys, the startup guys, maybe some of these were startups at one point themselves, it takes sort of a lot to get user attention. It takes a lot to sort of move the market share needle. In that space, or in that reality, doesn't a new law, a targeted law, make sense?
So the reason why it doesn't, and this is not wearing a client hat, but from a competition law perspective, the entire idea of the current Competition Act is based on the notion of the consumer welfare standard, where you look to protect the process of competition. You do not look to protect a competitor, right? So when you're going towards the digital competition bill and an ex-ante regulation, what you're looking at is protecting not the process of competition and not fair outcomes, right? But to protect specific competitors, which is not the purpose of antitrust. What is needed, yes, in terms of ex post, which the CCI is already looking at, even for digital economy players, the delay lies in the investigation, the delay lies in the overburdened courts, right? What is needed perhaps is what is in the IBC. You need a statutory framework which is time-bound, and where you have a specialized competition appellate tribunal reinstituted, or specialized competition benches, so that these competition cases, whether they're digital economy or not, do not then languish for a 5 to 10 year period.
Trust me, as Nisha, somebody who's covered IBC very closely, the dirty dozen are still not resolved. Let me get Avaantika here. Avaantika, Nisha's made a very strong case that, we don't need this law at this stage. But the reality is that, once the committee has submitted its report, the bill is out. We are sort of post that point where we can argue against the need of this law. Come in here very quickly. First, on your quick thoughts on what you made of the approach that the committee took in drafting this new bill.
No, I have to agree with you. I think it's now imminent. I don't know if it makes sense for us to argue that we don't need this law. I expect, like the rest of the world, we will see this law take effect eventually. The question is how and in what form. Again, I wasn't part of the committee, so I don't have the details on its approach, Payaswini. But from what I can make out, there's a lot of reference to international sort of developments, and equally, the committee has sort of considered the multiple cases that I think the committee had the benefit of having insight into, because these are fairly public investigations run by the CCI. So that's about it on the approach. But I think to add to what Nisha said, I have to say that this law may be imminent, but we've had enough jurisprudence now in the competition space to know what the possible pitfalls may be. We also don't know whether this law will actually heighten innovation in India. I mean, we've acknowledged that we are an innovative economy. But I think my fundamental problem, and not wearing any hat here, with any sort of regulation is that is it an enabler, or is it something that's reining some parties in the hope that others will grow because the big guys reined in? I'm not philosophically sure that approach will serve the economy or the country very well.
Okay, Avaantika, I mean, I'm guessing some of the fears that you've called out don't come to be true and we don't stifle innovation. Nisha, I think the question to be asked at this point is that while, the committee has listed several behaviors that this law will sort of seek to look out for and then maybe, punish, if I can use the word, or penalize companies who are exhibiting that behavior. Can you explain to me in practical terms what are some of the use cases of this law? Preferencing is one broad area that the committee has mentioned. Anti-steering sort of behavior is another one. Use of public data to then profile individuals and do targeted advertising. This all seems sort of behaviors that you and I as consumers of marketplaces, aggregators face on a day-to-day basis, right? Today, if I go on Instagram and start looking for a particular sort of product, I can then see on my Google search, on my Facebook search, all of those companies, etc., coming back to me in my face that, hey, look, this is the product that you were looking for on X website. But now they show up in my sort of feed and other sites, social as well, because a lot of these are parent companies and, sister concerns. So that data is clearly getting shared. Can you articulate for me what are some of the behaviors prevalent today in the market that this law this proposed law will then check?
So first, to be clear, there is nothing that this new proposed law will check which isn't already being checked. under the Competition Act in terms of
take your
abuse of
point.
dominance.
I take your point,
It's
but
the
I'm
approach.
just saying,
It's the approach,
yeah,
right?
I'm just saying that behavior takes longer to check in the Competition Act. So hopefully this will be a shorter route.
So no, what happens here is basically once you're designated as a significant SSDE, right? Once you're designated as an SSD basis financial thresholds, financial reach, or even if you don't meet either of these criteria, if the CCI is of the view on 16 factors, the last of which says basis any factor that the CCI considers, that you have significant influence and you're a digital economy player, which effectively offers a core digital service, then the CCI has the ability now to regulate you, right? So that regulation basically means certain obligations will apply to you irrespective of whether you do something or you don't do something. From the start, once you're designated an SSDE, you have to ensure that you don't do self-preferencing. You have to ensure that in terms of data, you have the relevant consent. You again don't preference your particular lines, and you don't disadvantage your business users. You don't do tying and bundling, right? You don't do anti-steering, and therefore all these obligations are predefined and pre-identified. They also have in place a set of 9 core digital services which will apply to each of these designated SSDEs. And here is where they've moved from a principle-based approach, because the principles are these obligations which are clear across the board. But for each core digital service, right? Because as a platform, you could be providing more than one core digital service, and there could be more than one player in this space who's offering that core digital service, who has significant influence, so to say, and therefore each of their regulation will be tailored, right? So the Commission one-on-one will then customize it, which then is a hybrid between EU's DMA, the Digital Market Act, and UK's proposed DMCC bill, to see what level of conduct this particular enterprise for that core digital service needs to comply with, basis the number of its users in terms of time and manner of compliance, right? And this applies across the board because it applies to social network platforms, it applies to search engines, it applies to online intermediation services, which cover the gamut, from food delivery to cab aggregators to online travel agencies, right? So literally every aspect of doing business for a digital economy player now will pretty much fall within this core digital service. And these core digital services have been defined in a schedule with a residuary power that they can be extended. And every 3 years, the central government, in consultation with the CCI, will reevaluate them.
Right. But I'm...
right, so the use cases, to be clear, right, would literally travel the gamut, right?
Yeah.
You want to take a cab, covered. You want to order from an online food delivery platform, covered, right? You want to order from an e-commerce platform, covered. You want to book your flight tickets on an online travel agency and your hotels, all covered, right? You want to do a search on the web, covered. So the entire gamut stands covered today under these core digital services.
Just to close the loop on some of the references that Nisha made, the draft bill says that the proposed law will apply to systemically significant digital enterprises, and this is sort of a concept that has probably creeped in this proposed law from the IT rules that we saw, made public last year. There's a dual test of significant financial strength and significant spread to identify these SSDEs, but there is also sort of a long list of factors that can qualify you as an SSDE. But I'll come to that in just a bit. Avaantika, come in here on your concerns about some of the overlaps that you saw in terms of penalties that can come through this Competition Act, and once this law, or rather this bill becomes a law, through this bill, through the Digital Competition Act as well. So for the same offence, your concerns are, in the shape and form this bill has been proposed, an entity can be penalised twice.
Exactly. And this is because there is no exclusion to, once you're identified as an SSDE, post that, there is no restriction on a possible claim also being initiated under Section 4 of the Competition Act, which is the abuse of dominance, which is in fact the provision under which most of the investigations by the CCI in the digital space have been initiated. My problem with that is that what are we envisioning here? We are envisioning two statutes. You have the Competition Act, and then you have this draft bill, which regulates digital competition. And then what is going to happen is that parties have to self-assess and are required to report to the Commission that, yes, we qualify for the criteria that have been listed, and we are an SSDE, so designate us so. And then they have to comply with Chapter 3 of this draft statute. And if they don't comply, then there is a potential penalty of up to 10% of the global turnover, which, as we know, is not a mean sum. The same entity could be proceeded against under Section 4 of the Competition Act for potentially exactly the same behavior that it violates Chapter 3 for, allegedly. And then there is that process of the DG, the exact same mechanics. The DG investigating whether or not there is an abuse of dominance, and as you said, Payaswini, earlier on, whether in fact the enterprise is dominant itself, which I think should be easy. If it's declared itself an SSDE, then perhaps there's a high chance that it'll also be found to be dominant. And well, it's a self-assessment. It's declared, it's sort of reported to the Commission saying, well, I meet this criteria. So the question is then, does it become dominant or not? And yes, lawyers will get very busy, but I'm sure that's not the aim of this legislation. But we will get busy arguing that merely being an SSDE does not make us dominant in said relevant market. We will argue the very same arguments to a great extent, saying that we are compliant with Chapter 3, and no, we're not abusing our dominance. And ultimately, the very same regulator, the very same individual members of the Competition Commission of India will make a finding on whether or not I have violated, the Digital Competition Act, and whether or not I have also, while I was doing that, abused my dominance. There is no provision in the law as it reads right now that there will be some form of reasonableness and proportionality to this, because there's going to be a multiplicity or duplicity of proceedings, and will there also be a duplicity of penalty? And in the long run,
if I can come in here, that you could be penalized based on the proposal under the draft digital competition bill, 10% of your global turnover, and so is under the Competition Act. So theoretically speaking, you could look at up to 10% under the existing statute and the proposed one.
Well, this is 10% of the preceding financial year, whereas under the Competition Act, the 10% threshold applies to an average of 3 years turnover. So no, it's not the same thing. And the statute at least doesn't read as if it were covering the same subject. And therefore, there has to be some provision. And I know that the committee deliberated on this subject, and it was, some of the Commission's own submissions have been that, there are hurdles to, enforcement under the Competition Act, and that, it's better that they also have this SSDE identified by themselves so that they're able to, more emphatically enforce Competition Act. There's also some discussion on the fact that the Commission should keep in mind when it's running these two parallel proceedings, sitting as a judge in both proceedings, that it might penalize the same party for violation of the Digital Competition Act, and so therefore it must keep that in mind when it penalizes under the Competition Act. But this is not in the statute. That's something the committee discussed, And I believe that as part of the public comments that will no doubt be submitted, I think some amount of rationality in the way that this law, if it does come into force, is brought into force, I think is going to be very, very important. Because what you don't want is uncertainty. What you don't want is chaos and mayhem.
Nisha, one gripe that you have in the bill is the inspiration we have drawn from the Digital Markets Act, which is the law in the European Union that provides for exemptions for quote-unquote gatekeepers, which has not been to the full extent, adopted here. To a certain extent, the committee has said that the exemptions should be encoded in the statute, but they've not gone the full hog. Explain to me, why is that a concern?
So in Europe, if you qualify as a gatekeeper, basis quantitative and qualitative criteria, you're automatically not designated as a gatekeeper to whom all of the do's and don'ts and the obligation apply. You have the ability, despite qualifying quantitatively as a gatekeeper, once you self-report, to build a case for an exemption before the European Commission. So for example, Microsoft was able to get it for Bing, where you're able to demonstrate that in that particular service, despite you as an overall entity being a gatekeeper, that service is not large enough for you to be regulated. That does not exist in our current version of the draft competition bill. It is hoped that by way of public comments, since we are copying from Europe, we do a fulsome job and don't just cherry pick, and therefore have the ability where an SSDE whose core digital service is minimal should really not be regulated for that core digital service.
Okay. Avaantika, what are some of the use cases in the Indian market for this exemption to your mind?
Well, that's difficult to say, but again, it could be, and I don't want to take names, but it could be, an ancillary to say the fact that you provide, you also provide delivery services when you're a cab aggregator. So will that service should not be qualified as a core digital service. It could just be that. It remains to be seen where this might be used, but I want to add that I don't think we have to copy only from Europe. We can copy from other places where it's likely beneficial. But even in the UK DMCC, where the behavior benefits users, or where there is a countervailing impact, that is, the benefits outweigh the so-called harm, there too there is a possibility of an exemption. I believe that there is some rationale in incorporating such exemptions into our statute as well.
All right, Avaantika, the big miss that we just talked about, and I want to come to you for that, is the proposed bill is not going to cover killer acquisitions, and the committee says the deal value threshold in the Competition Act is sufficient to address concerns on that front. I looked up certain numbers on what the killer acquisitions recently have been, and actually the idea emanated from the standing committee report, which said that these are the deals that are escaping CCI scrutiny. So we put a 2,000 crore sort of threshold for that. If you look at certain numbers in terms of what the killer acquisitions have been, there have been many in this space that have been less than 2,000 crore. Myntra's acquisition of Jabong was 470 crores. Ola's acquisition of Taxi for Sure was 1,200 crores. Most recently, Baiju's acquired White Hat Jr. for 400 crores. Do you believe that the committee has, rightly omitted mergers and acquisitions from the purview of this new law?
I'm interested, and I don't represent any of the parties and didn't work on any of the transactions that you stated, but I'm interested on why we believe these are killer acquisitions at all. Merely because I'm acquiring a competitor doesn't mean that I'm engaging in a killer acquisition. A killer acquisition is, my understanding is, intended to ensure that the competitor does not provide a service that could in the future compete with my own. Mere consolidation or buying of competitors is not a killer acquisition. And if it is, then, well, you do have, so-called killer acquisitions, even in the non-digital space, that go unscrutinized. And the answer has always been that, well, the Commission can always pursue an investigation under the abuse of dominance provisions under the Act. I believe the same argument would apply for so-called killer acquisitions. Also, this is exactly what the
word. I'll use the kinder word that you mentioned, Avaantika, which is consolidation, which is to say that, okay, fine, you are acquiring, a competitor, which then will make you probably the only player in some of the markets worth of any sort of size that the user would want to engage with. In those cases, like you mentioned, that currently we don't probably look at it in the offline space. Well, now we are deliberating on a new law. So to say that, look, we made a mistake there, to be able to copy that mistake here and continue making it, why leave it? Okay, the CCI can always say that, okay, we are not looking at M&A, and suddenly an M&A comes which really wants to be looked at. It should be, the regulator should be at least empowered to look at it, right?
Right. So, yeah, let's look at that. Then maybe we found why the catch-all exists. The catch-all that we were talking about under Section 3.3 of the draft competition bill, where it says that even if none of the criteria are met by an enterprise, the Commission is at liberty to declare that it is in fact an SSDE. Perhaps that is why the catch-all is, although I argue that it has unknowingly been put there, perhaps in a bid to empower the Commission more than was necessary, given that we are targeting objective criteria and in the identification of our gatekeepers in India. But sure, I mean, an enabling provision, I fully agree, should exist. I'm not sure it's a miss. I believe that the draftspersons have considered the deal value threshold, and they feel that that's the one that's going to catch digital acquisitions that may lead to a consolidation that creates a possible monopoly under the law. I fully agree with you, however, that that threshold that has been determined by the Commission is not really, or rather the Ministry, is not really the appropriate threshold. But then India has very high thresholds in merger control, where it's been well acknowledged that our merger control thresholds are amongst the highest in the world. So we'll perhaps never
continued with this benevolence in the proposed law as well. Avaantika, Nisha, many thanks for joining me here with your quick takes on the draft digital competition bill. And of course, as this bill makes this journey to a law, we'll remain on top of it after stakeholder consultation, the final version as well. Thank you for joining us here on NDTV Profit.